he has to go to pretrial and his bond people.
How old are you?
I'm 21 now.
All right, so you're 21. Under the eyes of the law, you're an adult.
Yes, ma'am.
You need to be responsible for one. A is going to be Zach's last day because he has too much trial experience. They're moving him to intake. So,
No, Judge.
I
won't go.
say nice, be nice, be kind to him. Wish him luck in intake and that he will enjoy it. I always say, bloom where you are planted. So we're going to miss you, Zach.
Absolutely. Thank you. I'll miss you too.
All right. Aw. Okay, docket is canceled. All right, so you're filing a motion to withdraw?
That is correct, Your Honor.
Why?
So our client is dissatisfied with the services he received. He's already discontinued payment of the retainer. He's seeking to terminate our services to seek out a new attorney, Your Honor.
All right. So here's the court's issue with your motion to withdraw. How long have you been on this case?
Attorney of record was Anthony Wilson, Your Honor. I can't say exactly how many hearings he's had as the attorney of record.
Ms. Ferguson, when were they the attorney of record?
Seems like it was on March 15th of 2024.
All right, so we're going to start with what has been happening since you've been the attorney since March of 2024.
I was not the attorney of record, Your Honor.
Who was the attorney of record?
Anthony O'Neill Wilson.
All right.
And he was the one that was hired, but he's with his law firm. Am I correct?
That's correct. He's in the same law firm. So.
All right, so we're doing word salad here, but that's okay. Let me divide this salad up. So April 1st, 2024, it was recalled for April 11th for a plea deadline date, and that was supposed to be the final plea deadline date. On April 11th, the plea deadline date was extended to April 15th because the defense counsel stated they were in Travis County. Even though Travis County starts with a T and not a B, that's where they were. April 15th, it was recalled to April 16th because defense attorney was no-show. April 16th, it was recalled to April 22nd, 2024 because the defense attorney was a no-show. On April 22nd, it was recalled for April 23rd for trial by Judge Angelini. Then on April 23rd, it was recalled again for April 24th by Judge Angelini for a jury trial. Then on July 9th, it was recalled for July 10th for jury trial. Then on July 15th, it was set for jury trial, September 9th, 2024 for impact court. Then on August 5th, it was set for a motion to withdraw by counsel and defense attorney was a no-show. Motion to withdraw is denied. Y'all need to be in impact for jury trial on September 9th. And they'll bring you over dressed for trial. They'll bring you over dressed in whatever clothing you have at the jail. If you wish to be attired in something different, then you'll need to make arrangements for with your attorney to do a clothing exchange. If there is an issue with the clothing exchange, let the court know, and the court will see if I can help you with that, expedited. All right, thank you.
And you know, if I may, as Anthony O'Neill Wilson is the attorney of record, no one other than him has access to discovery. He's poorly handled this case. There is no record of him actually ever downloading discovery. It's not like it's in the client's file.
So far, you've seen confusion, delays, and frustration inside the courtroom, attorneys shifting blame, missed deadlines stacking up, and even a young man struggling to understand the rules of his own case. The judge's patience has been tested, and the stakes are rising. But now, as we move forward, the tension deepens. A tragic collision, a nervous defendant facing life-altering charges, and the shocking possibility of a case dismissed for further investigation. What unfolds next will change everything.
Since we're going to be held onto this case, I do ask that it be expedited to put me as attorney of record so I get access to the discovery as soon as possible, as early as today.
Right, and my understanding is that your firm, he was with your firm, correct?
Yes.
All right. So, Ms. Ferguson, just make sure that his name is there. But I will tell you, since your firm is listed as the firm, your firm should have access to the discovery. But if you're saying your firm doesn't, which I find that hard to believe since the previous attorney was a member of your firm, we will make sure that that happens. But a motion for continuance will not be granted because your firm is saying it does not have discovery when your firm should have discovery because you have a firm. The attorneys work underneath the umbrella of that firm and all that discovery should be there. All right, thank you. Is there anything else? Thank you.
Thank you.
Hello, how are you doing? Yes.
It's a lovely day, Judge.
Yes. All right, we have a violation report. Your client missed a setting, well, an appointment with pretrial services.
Yes, Your Honor. I tried to contact him.
Everyone, will you all please whisper? But if you're not going to whisper, bring that same level of tone when you're before the bench so I can hear you. Yes.
I finally was, the numbers that we had, that the pretrial had was his mother's telephone number. She works. I was able to call early enough yesterday that I finally got a hold of her. Apparently, Mr. Vasquez was not staying at the home. Are you staying somewhere else?
No, you, sir.
Yes. So I don't know if she didn't understand who the numbers were. He's been reporting to his bonds person. Nobody ever told him, Your Honor, I would ask that he be allowed to go now that he understands he has to go to pretrial and his bond people.
How old are you?
I'm 21 now.
All right, so you're 21. Under the eyes of the law, you're an adult.
Yes, ma'am.
You need to be responsible for one, your own case, as far as showing up. Just, I don't know why. And when I was a defense attorney too, people would say, well, my bondsman never told me. Well, your bondsman will not be going to jail if you don't show up. Do you understand?
Yes.
So with this pretrial services, you need to be in contact with them. Do you understand?
Yes.
All right, just have a seat. Ms. Ferguson, can you have his pretrial services officer zoom in? We're going to have his officer zoom in so they can have all of your contact information. Do you understand?
Yes, ma'am.
All right, so just have a seat.
May I be excused, Your Honor?
Yes.
Thank you. You don't need me for that.
Yeah.
Thank you.
Attorney on Johnny Ruiz Jr. I think it's criminal trial division, collision involving death. Yes. All right, so I know there are probably still some outstanding discovery. Can someone tell me what's maybe outstanding? Do you have all of the medical? Do you have the autopsy?
I do, Judge.
All right, is there anything
Nice.
that's outstanding?
Not that I'm aware of at this time.
All right, so this is what I'm going to do. This is a first setting case. I'm going to set it in 30 days for you to make sure that you have all of the discovery. And then on that day, if you have all the discovery, I'm going to want an acknowledgement of discovery.
Understood.
All right, Ms. Ferguson, I need a 30-day reset on Johnny Ruiz. State you're excused.
September 30th.
All right, we're going to come back on September 30th. All right, Mr. Ruiz, when you come back to court, no t-shirts, you understand?
Yes, I saw the last one. I do apologize. I'm nervous and I just wanted to feel comfortable.
Oh, no problem. Here's the thing, unless somebody tells you what you don't know it, right? And so I always tell people it doesn't have to be a three-piece suit, right? Because I don't have a three-piece suit hanging in the closet, although I would like one, but I don't have one hanging in the closet. So,
Understandable.
all right, so once you sign the reset form, you're excused. So what's going to happen? We're going to come back on September 30th.
Mhm.
On that date, your attorney is going to let me know if he has all of the discovery. If he doesn't, hypothetically, let's say he's missing a medical report. He'll let me know he's missing a medical report. Then we'll give a reset date for him to make sure he has that and the state turns it over. I want to make sure that he has all of the discovery so we can proceed.
Yes, ma'am.
All right. Do you have any questions about the process or anything? All right, just take a seat. They're going to give you a reset form. And once you sign it, you're excused, and make sure you put your email if you have one on the reset form. Okay.
Yes, ma'am.
All right. Thank you.
Thank you, Your Honor.
And to think you almost were going to leave this case. See, attorneys do work hard. You understand?
Yes, ma'am.
And I still remember you maybe not wanting to speak to your attorney.
We got off on the bad foot.
Well, I mean, you got off on the bad.
I did, yes.
Yes. All right, so the state has filed a motion to dismiss for further investigation. What that means is Maybe it's going to come back, maybe not. I don't know. You understand? Defense, you have no objections to the court signing the dismissal?
No, you're not.
All right, you know what happened to cause you to be in this situation? Whatever happened, don't let it happen again. Because
ma'am.
this case, 5 to 99 years or life, okay?
Yes, ma'am.
All right, here you go, counsel.
Maybe excuse, Judge.
Yes.
Thank you. Thank you.
Salinas?
The courtroom that morning was not merely a chamber of law. It was a stage of raw human conflict, delays, and lives hanging by threads. The gavel struck, but order was fragile, and beneath the surface of legal jargon and scheduled hearings, emotions churned. It began with a stern reminder of responsibility. A 21-year-old defendant, barely an adult, tried to explain why he had missed pretrial obligations. He had reported to his bondsman, but never to pretrial services. The excuse was familiar, one that countless defendants before him had voiced. "My bondsman didn't tell me." Yet the judge's voice cut through his explanation like steel. "Your bondsman will not be going to jail if you don't show up. You are an adult. You must take responsibility." In that moment, the defendant's youth collapsed under the weight of adulthood in the eyes of the law. But even before that warning, another tension had surfaced. A lawyer, Zach, was saying farewell. It was his last day in that division before being moved to intake court. The goodbye seemed lighthearted, even warm, but beneath the pleasantries was a hard truth. Attorneys rotate, judges preside, but defendants remain trapped, waiting. For them, stability is a luxury, and change can mean another layer of confusion in a process already filled with it. That confusion exploded with the case involving attorney Anthony Wilson's firm. A motion to withdraw revealed the defendant deeply dissatisfied with his representation. Payments had stopped, trust was broken, and deadlines were missed. The judge recited the history of delays like an indictment against the defense itself. Hearings were called, attorneys absent, excuses piling up. From April through July, the case had bounced like a ball across the docket. Word salad, the judge called it, before untangling each misstep. The system, meant to bring justice, instead seemed to drag the defendant deeper into uncertainty. And then came the discovery issue. The attorney admitted there was no record of discovery being downloaded, no evidence files in the client's folder. The firm claimed only the previous attorney had access, though he too was part of their team. The judge's disbelief was sharp, almost incredulous. Your firm should have access. The attorneys work underneath the umbrella of that firm. All discovery should be there. She made it clear, delays and excuses would no longer be tolerated. The message, justice cannot wait because of poor communication or neglect. From there, the docket revealed another human struggle, Mr. Vasquez, the same young man who misunderstood his pretrial duties. His attorney explained they only had his mother's number and that he hadn't been living at home. He seemed lost between adolescence and adulthood, unsure of the system's expectations. Yet the judge, though stern, took steps to help him. She arranged for his pretrial officer to zoom in and collect updated contact information. The warning was clear, but not without compassion. Ignorance may explain a mistake once, but it cannot excuse it again. Then the atmosphere grew heavier. The name Johnny Ruiz Jr. was called, his case tied to a collision involving death. Suddenly, the stakes felt immeasurably higher. The court asked about discovery, medical reports, autopsy documents. These weren't just files, they were pieces of evidence tied to someone's life, and now they stood between Ruiz and his fate. The judge allowed 30 days to ensure discovery was complete, but the weight of the charges lingered. Ruiz himself appeared nervous, even apologizing for wearing a t-shirt. He wanted to feel comfortable, but the judge reminded him, respect the process. It doesn't have to be a three-piece suit, but no t-shirts in court. Her words struck a balance, stern but with a touch of humanity. She explained gently, unless somebody tells you what you don't know it. For Ruiz, it was more than about clothing. It was a lesson in navigating a system that gives little room for error. Yet the most shocking twist came near the end. A case, one that carried a possible sentence of 5 to 99 years, even life, was dismissed for further investigation. To the casual observer, it might have seemed like a victory for the defendant, freedom, at least for now. But the judge's warning froze the air. Whatever happened, don't let it happen again. The dismissal was not closure, but a shadow. The case could return at any moment, and the defendant's reprieve was fragile, temporary, perhaps even deceptive. Justice had not ended, it had only paused. Throughout it all, the judge emerged as the steady hand in chaos, sometimes sharp, sometimes compassionate, always aware of the stakes. She reminded one defendant to dress with respect, another to take control of his case, and attorneys to fulfill their duties without excuses. To the untrained eye, the courtroom might have looked procedural, even mundane. But every correction, every delay, every dismissal carried the weight of human lives forever altered. And so what began as routine hearings unfolded into a tapestry of responsibility, neglect, tragedy, and second chances. A young man learning adulthood in the harshest way, a law firm exposed for incompetence, a nervous defendant tied to a fatal collision, a case dismissed but not erased. Each moment a reminder that justice is not clean, not swift, and never guaranteed. The final reflection is sobering. The law does not bend for confusion, for youth, or for missed obligations. It demands accountability, yet inside these walls, human flaws are on full display. The attorneys who failed to show, the defendants who misunderstand, the families who carry the burden. All of it collides under the judge's gavel. But perhaps the most haunting thought is this: justice is not only about verdicts and sentences, it is about the fragile trust between people in the system meant to guide them. And in that courtroom, on that day, that trust was tested again and again. Some walked away with lessons, others with warnings, and one with the fragile gift of a dismissal. The question that lingers is not whether justice was served, but whether it was ever steady at all. Is this the slow, careful grind of fairness, or the slow unraveling of justice itself?